which is always a good place to start. They concede that public participation is necessary for purposes of the impeachment proceedings that are before you. They concede that judicial oversight is within the powers
of this court as regards the impeachment proceedings.
They then muddle up their submission somewhat at paragraph 107 by stating that impeachment is a purely political process rather than a judicial one. At paragraph 107, they seek to limit the purview of this court's mandate by stating that the court review of the decisions or the process does not include interrogating substantive merits of the impeachment charges. They, however, concede at paragraph 109 that this court has jurisdiction and power to examine whether the constitutional and statutory procedure for the impeachment was followed lawfully. That's paragraph 109. They concede as well at paragraph 109 that this court can examine the question as to whether the petitioner's rights were violated. I believe they are citing a decision of the Court of Appeal in making that concession. They then repeat at the same paragraph that the court cannot reevaluate or substitute or interrogate the substantive merits of Parliament's decision. And I'll be demonstrating to this honorable court why that is not the correct position. Having conceded that public participation is necessary, as they have at paragraph 95, they then seek to somehow circumscribe their concession at paragraphs 292 and 294 by saying that Senate did not require to conduct public participation. It's the boldest statement negating public participation I have ever had by a state organ. At paragraph 183, they make the point that fairness is required as a part of the process and that it requires careful consideration. And as regards what my learned senior counsel, Mr. Paul Muite, alluded to here earlier this morning regarding the events of the night when the IBC was consulted leading to the nomination of the current deputy president, they make the point at paragraph 380 that the National Assembly was not conducting a normal vetting process. It was a vote. In fact, they make the point that it was an election. Those are the words they use. And this is now to be found in the submissions of the first and eighth respondent at paragraph 68 to paragraph 70, that the president, in consulting IBC on that night, was not doing so as a matter of constitutional requirement, but was doing so as a matter of abundant caution. He was being careful. He didn't require to do so. Those are the points they make. Now, this court is imbued and clothed with authority, first and foremost under Article 22 of the Constitution of Kenya, and I don't need to read all the remedies that are set out therein. But among those that are set out there and relevant to our client's case, one is compensation, E, and F, an order for judicial review. And then at Article 165, subarticle 6, the High Court has supervisory jurisdiction where it is examining a decision arising from a quasi-judicial proceeding. And this is important for reasons that I will make known shortly. Now, I call this court's attention to Section 11 of the Fair Administrative Action Act, and it's an important act for many reasons, because whereas Parliament has made very lengthy submissions on many things, Parliament constitutionally talks through the laws it passes. This is a law Parliament passes directing what is to be fair in a proceeding such as this. And I begin first by making the point, and the respondents agree with me on this, and I'll be demonstrating where the submissions. They say that the Senate proceedings were quasi-judicial. That is the word they use themselves. And perhaps I think I should actually identify the exact paragraph where they say, I believe this is paragraph 292 of their submissions, where they say that the Senate was exercising a quasi-judicial authority. Yes, indeed, at paragraph 292 of the submissions by the National Assembly itself. And this is what they say. We submit that the Senate's function under Article 145 is not a legislative function, but a quasi-judicial and adjudicative role. The words quasi-judicial are the same words appearing, as I've stated, at Article 165, Sub-Article 6. But perhaps more importantly, under Section 2 of the Fair Administrative Action Act, and the Act begins by stating, this is the rationale for the statute by Parliament itself, this is an act of Parliament to give effect to Article 47 of the Constitution of Kenya. And this is what they say. Administrative action is defined as the powers, functions, and duties exercised by authorities or quasi-judicial tribunals. And so, by concession, by admission of the Senate, the decision, the process they undertook was quasi-judicial and therefore amenable to the Fair Administrative Action Act. And this is important because at Section 5, the statute says that in any case where the proposed administrative action is likely to materially and adversely affect the legal rights or interests of a group of persons or the general public, it then says what must be done. Amongst the first things that must be done is that there must be the issue of a public notice of the proposed administrative action inviting public views in that regard, public participation. Senate was required by the statute, by Section 5, to conduct public participation. They have admitted they did not do so. Number two, they are to consider all views submitted in relation to the matter before taking the administrative action. They were to consider everything said to them during public participation. They elected not to do so. They are to consider all the relevant and material facts. And D, where they proceed to take the action, they are to give reasons for the decision of the administrative action as taken. Again, they did not do that. That was not done. Now, and my good and learned senior here, Mr. Swanya, will be coming to give a few more details on the question of public participation, and I'll touch on a few others. But then, at section, I believe, section 7, subsection 2, this court is provided with a marking scheme. It is to apply when considering whether administrative action such as this met the test of the Constitution and of the law. I have been shocked in my own examination of the question to find that the National Assembly and Senate reached a mark. The examination mark was equivalent to my Form 2 physics examination, 0 out of 100. That is the figure they found. A self-supporting 0, and I'll proceed to demonstrate the points. Section 11, Section 7, subsection 2, I've read out to the court, states that the person who made the decision and this is one of the criteria that the court is to look at, whether that person was not authorized to do so by the empowering provision. Now, you've been told, and as I've pointed out here, the respondents make the point that the president was only acting as a matter of abundant caution. Now, it is not in dispute, I think it is common ground between us, that the IEBC did not have commissioners or a chairperson. In 2025, the Supreme Court of Kenya handed down a decision. It is part of our list of authorities. It's called IEBC versus the Attorney General, 2025. At paragraph 62, this is what they say. It is uncontested and indeed a matter of public record that at the time of filing of the present reference, IEBC was not fully constituted following the exit of its previous commissioners. There was at the time no indication as to when new commissioners would be appointed. As such, the commission remained for all practical and constitutional purposes incapable of discharging functions that by law require the participation, deliberation, or approval of a properly constituted commission in accordance with Article 251 and 252 of the Constitution. That is a binding decision on this court, and if there were any doubt as to whether the president was actually required by law to do this, or whether he was actually acting as a matter of abundant caution, as it states, I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IEBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything. You cannot violate that which does not exist. That is amenable to review by this court. One of the other tests is whether the decision was made in excess of jurisdiction or power conferred under any written law. Now, the Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon. But apart from that, as regards the appointment of a replacement candidate, the Constitution has 74 days within which this decision could be made. 74. It was made at night, within less than 24 hours. So this kind of, there was no power to act with such ungodly haste when you are allowed 74 days to take your decision. Now, the speakers of both the National Assembly and the Senate, as my good friend Lisha Ongoya said here earlier, were beneficiaries and signatories of shareholder agreements which have been placed before you, which formed the basis of grounds 1, 5, and 6 of the impeachment motion. One of the fundamental rules of natural justice is that you cannot sit in judgment of your own cause. They were sitting in judgment of a cause in which they were not only beneficiaries. In the case of the National Assembly Speaker, who I have tremendous regard for, he was a signatory. As senior counsel here said this morning, the replacement, Honorable Kithure Kindiki, professor, a man I have a lot of regard for as well, was the witness of those agreements. The President of the Republic of Kenya signed and bound himself to those documents. And it's important to understand that these documents were not being done as a matter of abundant caution or as a matter of political games. The Political Parties Act requires a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the deputy president, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your deputy president. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution.
And this is what they say. This dual role is unlawful and unconstitutional.
I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so, when Parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this, but they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was 0 public participation, mathematically. It's that simple. 200,000 people out of 14 million is 0. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%. And these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the deputy president. This is the National Assembly. But then don't give the people what the deputy president's responses are. And this is not an idle issue I'm raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaint, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which we'll find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the deputy president is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you are praying for him, we will proceed here to hang him as you are praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend Mr. Dudley here again has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that, but the courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. Said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act, but again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election,
it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later.